If you're handling a loved one's estate and there's a house involved, you might assume that once probate is filed, the sale can close as soon as a buyer signs. But in California, title and escrow can't just process the closing. They need specific court documents first, and without those, your sale can stall, get delayed, or even fall apart. I'm Shanti Sower Jono. I specialize in California probate and trust real estate, and I help families work through these exact requirements every week. The documents you'll need depend on whether the personal representative has full authority under the Independent Administration of Estates Act or only limited authority. That distinction is important. But in most probate sales, there are 3 documents that title and escrow almost always need before they'll let the sale close. First are the letters. The official names are letters testamentary or letters of administration. This is the court-issued document that gives the personal representative legal authority to act on behalf of the estate. Letters testamentary are issued when there's a valid will that names an executor. Letters of administration are issued when there's no will or when the named executor can't serve. Without these letters, the personal representative generally can't sign the listing agreement, the purchase agreement, or the deed. If you're the one in charge, this is your legal proof that you're actually in charge. Second is the order for probate, sometimes called the order appointing personal representative. This is the court order that officially appoints the personal representative and states what level of authority they have. It says whether they have full authority under the IAEA or limited authority. Escrow and title review this order to determine what the personal representative can do on their own, and whether the court has to confirm the sale before closing. You might think once you have the letters, you're done. But this order answers a different question. How much decision-making power do you actually have? The third document is the Notice of Proposed Action, or NOPA, along with proof of service. This one comes into play when the personal representative has full authority and is selling real property under the IAEA. In that case, the personal representative generally has to serve a notice of proposed action on the beneficiaries and anyone else entitled to notice. Then they have to wait the required objection period. That's typically 15 days after mailing or 10 days after personal delivery. If no one objects, the sale can move forward. If the beneficiaries waive notice or give written consent, that can speed things up. Escrow or title may ask to see the NOPA itself, proof that it was properly served, and any signed consents or waivers. This is the step that families often miss, and it's a common reason closings get delayed. Beyond those 3, other documents may come up depending on your situation. A certified death certificate, a court order confirming the sale if court confirmation is required. The preliminary change of ownership report, often called the PCOR. The deed itself, whether it's a grant deed or a personal representative's deed, an affidavit of death in some situations, and any tax or title clearance documents the title company needs. Every sale is a little different, and escrow will give you a list once they review the file. So here's the short version. The 3 key documents are the letters, the order for probate, and the notice of proposed action with proof of service when it applies. These are the documents that let title and escrow verify you have legal authority to sell the property and that the probate process was followed the way California requires. Without them, closing simply can't happen. With them, you're in a much stronger position to get the sale done. Before we go, please remember that this video is general information only. It is not legal, tax, or financial advice, and I am not an attorney. Every estate is different, so talk to a licensed probate attorney about your specific situation. And if you're a personal representative, trustee, or beneficiary handling an estate that includes real estate here in California, I'd love to help. I offer a free, no-pressure consultation to walk through where you are and what comes next. I'm Shanti Sorjono.